Hello, everyone, and welcome to Uncivil Law, where we learn through others' misfortunes. To increase your legal knowledge, please hit the subscribe button. For today's case, we have United States of America versus Trayman James. In this case, Mr. James was convicted of some offenses, and they're trying to decide how much time to put him in prison for. Now, that under federal rules is determined by two things: how serious this crime is and how serious your past crimes are. And so the question at issue is whether or not a particular offense of which he was convicted in the past qualifies or not as a past offense for these purposes, because the federal law doesn't say that everything qualifies. There are some exclusions. So it's a difference of months to years in jail or prison, which one he's going to serve. So does a prior offense, in this case one of loitering, count or not towards his increased time? Let's find out. Early one morning in December of 2017, Trayman James's 10-year-old nephew found a loaded handgun in a kitchen drawer at the home. Bad firearm safety. As he was examining it, the gun fired mistakenly. The bullet traveled through a wall and wounded the boy's sister, James's 6-year-old niece, as she lay in bed. We are not off to a super promising start. She made a full recovery. However, the police arrested James for a violation of 18 U.S.C. 922, which bars possession of a firearm by those convicted of a crime punishable by more than 1 year incarceration. So he has a prior conviction, and he can't have firearms, and so when they found that out, they brought him under federal law to say he can't have a firearm. He pleaded guilty, and a sentencing hearing was held the following year. The pre-sentence report recommends a term of imprisonment between 84 and 105 months. So that's a pretty long time, when you're talking about being a felon in possession. That can come with some pretty serious charges. We're talking about some lengthy time. So how we come up with that number is the real key here. It assigned James a criminal history score of 10, including 2 points for a 2011 state conviction for loitering and prowling at night. That offense is a third-degree misdemeanor, which under Pennsylvania law is punishable by 1 year of incarceration. Okay, so the question is, he's a felon in possession, he has a firearm. They found the firearm because his nephew shot the boy's sister, and the police are looking into it and like, wait, you're not allowed to have a firearm. We know how bad this offense is. We got that down. We're trying to figure out what his prior offenses are, how much they count. And we're counting, as part of it, 2 years of third-degree misdemeanor in Pennsylvania for loitering. So does that count as a prior offense within the meaning of the federal law? Because federal law defines what is and is not prior offenses for its purposes. So does Pennsylvania's prior offense count as a prior offense for the purposes of determining this sentencing calculation? Although James initially received only 60 days probation for that offense before, subsequent probation violations led to a sentence of imprisonment for up to 9 months. The length of that sentence triggered the addition of 2 points. So one of the things that determines how bad your past crime is how much time you actually served, right? Because he did some probation violations, he actually served 9 months. So he didn't have to do that. He walked himself into that, and because of that, he's getting an additional +2 on this particular thing. At the sentencing hearing, James's attorney objected. The guidelines for sentencing, she pointed out, provide that a sentence for loitering and all other offenses similar to it should be excluded for computation of the criminal history score. So the attorney says, wait a second, the guidelines say that loitering and any offense similar to loitering do not count as a prior offense within the meaning of federal law. And the 2 points that this would be are significant. A criminal history score of 8 would have placed James in category 4, which a sentence of 70 to 87 months. Because of the score of 10, it put him in category 5, leading to 84 to 105 months. So if we didn't have this +2 enhancement, we would have been 70 to 84 months. And then because we did, now we're going to the top end of that and more. So we're talking about a difference of a year and change. So it's a pretty big deal, this additional 2 years, this additional +2. It's an additional year and change in jail that maybe we don't have to serve. So does it count or not? In order to decide whether the guidelines require the exclusion of James' sentence under the relevant law, we must begin by determining the scope of what loitering means in the law. So what does loitering mean for the purposes of federal law? Hines called this category loitering simpliciter and held it does not include offenses like that of New Jersey's anti-loitering statute, which requires a specific intent, subjectively held, and objectively manifested, in addition to the mere act of wandering, remaining, or prowling. So in a prior case, they dealt with this and they said, okay, there's two kinds of loitering. There's the one where someone is just hanging around, not doing anything kind of loitering. And there's one where they're also hanging around with some other specific intent in mind, subjectively held and objectively manifest, that they're trying to do something else in particular. So it's not just loitering, it's loitering with bad intention. So the decisions that are out there say loitering doesn't count, but loitering with bad intention does. And you have to be able to prove it, of course, but that's a whole issue of proof at a trial. These statements should not be understood to describe loitering simpliciter's ceiling to exhaust all possible offenses that make up the category. It's a fundamental canon of statutory construction. The words generally should be interpreted as taking their ordinary, contemporary, common meaning at the time Congress enacted the statute. This, as the prior case of Hines said, demands that we give up loitering in the law the meaning it possessed when the United States Sentencing Commission drafted it. So what did it mean when it was written down? What did it mean at the time it was written? What is the original public understanding of loitering? A review of the relevant history in turn leads to the conclusion that loitering under the guidelines encompasses more than offenses that simply criminalize wandering, prowling, or remaining in a public place. It includes all those offenses, even those without a mens rea requirement, a mental state requirement that does not require of their violator a purpose to engage in some sort of unlawful conduct. The first category comprises those laws that either explicitly require a purpose to engage in some kind of unlawful conduct or have been authoritatively interpreted to possess this requirement. So we are looking to those that have a requirement that you're doing loitering with bad intention. As a result, in the years after these cases, courts have overwhelmingly upheld against constitutional challenges laws that make it illegal to loiter for the purpose of engaging in unlawful conduct. So it's not just loitering, it's loitering with the purpose to engage in unlawful conduct. You're being a watchman, you're casing a joint, whatever. But it's loitering with bad intention. Some courts also have interpreted loitering laws to possess a mental state requirement in order to avoid the unconstitutionality issue. So that's category number one of loitering. The second category includes not only the sort of offenses invalidated in the prior law, which of course persisted until challenged, but also offenses of greater specificity regarding the conduct that they prohibit and grounds for arrest, though nevertheless falling short of a requirement of purpose to engage in unlawful conduct. In general, the laws of this latter group possess two features. First, they describe a circumstance-based offense, where conviction depends upon the circumstance of a certain objective and often enumerated condition. One especially common version, for example, penalized public loitering in a manner under circumstances manifesting the purpose of engaging in a particular unlawful act, such as drug trafficking. So there is this idea that we can get at it with if you can prove some specific purposes or specific intent in mind. State and federal courts divide over whether this second sort of loitering offense is unconstitutional. Laws containing one or both features were occasionally upheld, but they have been invalidated on other grounds as well. As to Pennsylvania's law, loitering in the guidelines is best read to encompass this second category of loitering offenses, all those that do not require, either explicitly or by judicial interpretation, a purpose to engage in some kind of unlawful conduct. An offense properly called loitering simpliciter may therefore still possess a mens rea requirement, provided that the element does not amount to a requirement of conscious object to commit an unlawful act. Because loitering in 1987 was a diverse offense, and because the lines between constitutional and unconstitutional versions of it varied across jurisdictions, loitering simpliciter is most aptly defined in this negative manner, that which it is not. We now turn to whether the offense defined in the law is loitering under the relevant guidelines. The Pennsylvania statute provides, whoever at nighttime maliciously loiters or maliciously prowls about a dwelling or house or any other place used wholly or in part for living or dwelling purposes, belonging or occupied to another, is guilty of misdemeanor of the third degree. So this is at night. You can't just merely hang outside their house or prowl, which presumably it would be best interpreted as like walking around the periphery, maybe looking in through the windows and stuff. That's not going to fly. That's the kind of thing they seem to be talking about. James contends the offense described here constitutes loitering in a simplistic form because it is essentially equivalent to that of the Model Penal Code's provision. Although the term malice in the statute might, on an independent inquiry, have led to a different conclusion, the Pennsylvania courts have construed the statute to require an affirmative purpose of a person to commit an unlawful act. So one of the first questions we might say was, what does it mean to be maliciously prowling or maliciously loitering? Well, fortunately, this is an issue of Pennsylvania state law, and the Pennsylvania courts have already answered it, at least in part. And they've said that whatever else it might mean, maliciously prowling, maliciously loitering, requires an affirmative purpose that you're committing an unlawful act. You're looking in the joint to check it out, or stuff like that. You're casing the joint, that kind of thing. So we're looking for something more than just merely hanging out in someone's house at night. Second, the statute is a conspicuous exception to the adoption of model penal code's other public order provisions. The requirements of the title of Pennsylvania statutes contain 9 offenses currently in force. Of those 9, only the language of loitering does not substantially match those of the equivalent offenses of the model penal code. So the model penal code is, as the name implies, a model, and it's something that lawyers work out from very well. And because it's pretty good, and it is a good summary of the law, and some places adopt it literally. And Pennsylvania has made some deviations, so you have to go look to what Pennsylvania specifically adopted. Makes sense. Although the statute is distinct from loitering in its simple form, we must still decide whether it's sufficiently similar to that of a class of offenses to warrant exclusion of James' sentence from his criminal history score. Under the guidelines, a court should never count sentences for offenses similar to loitering in its simple form, by whatever name they're known. Yeah, we don't look to what it is on the label, we look to what it does. Some courts have highlighted this language, thinking it supports considering any offense dubbed loitering to be at least similar to the loitering offense contemplated by guidelines. However, to us, the proper focus of the inquiry should not be on the name of the offense, but rather the features, what it is in the bottle, not what it says on the bottle. We therefore give no weight to the fact that this section is called loitering and prowling at nighttime. You could have called it anything else, but whatever it is, rose by any other name would smell sweet. So we don't look to what you called it, we look to what it is and whether or not it meets with the enhanced loitering that we are going to require to use it as a predicate offense. Although by some measures, both the law and its application to James are indeed similar to the offenses that comprising the simple form of loitering, we nevertheless conclude that in balance weighs against him. For one, the statute's 1-year maximum term of imprisonment is comparable only to the maximum punishment of a relative outlier in the range of punishments commonly available for violations of loitering. Provisions we acknowledge to constitute loitering in its simple form. So, because the sentence is so long, that suggests it is not loitering in simple form. Further, the sentence James received upon revocation of his probation also sits at the high end of that range. Finally, the statute's mens rea requirement categorically distinguishes it from a loitering offense listed in the statute. Collectively, these considerations are sufficient to render the sentence imposed on James for a violation of the law. We therefore affirm the judgment of the district court. Thus, that brings us to the end of this case of United States of America versus Tremaine James. In this case, Mr. James was a felon in possession of a gun. And the police came to this knowledge because his nephew found it and then shot his sister. And they charged him with being a felon in possession. And they're sending him to prison for quite a long time. But the question is, how long? And trying to reach that determination, we have to determine whether one offense in particular counts as a prior offense. He was convicted of loitering, which is a violation of Pennsylvania law. But the statute, although the guidelines say not to count loitering, it's been interpreted to understand only loitering in its simple form, not in forms that require a mental state of more nefarious wrongdoing. So in this particular version of it, his conviction was for this more nefarious version. He was loitering with intent, negative intent. And because that's not the simple version, it can be factored in. So he will have to serve an additional year in jail that he otherwise wouldn't have submitted. But that is the way the law reads. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.